your cell phone, make sure they're turned off or on silent, please.
Let me stop you. Oh, come. That's the guy I was talking about. This guy.
Yeah, yeah.
That's the
Manley.
2017.
Yeah,
Does he wanna?
I just got that yesterday, so I haven't,
I
had a chance to
forget
talk
that
to him about
because.
it.
Okay, can you ask? Because the other thing is, I can offer probation.
It's not, what's the charge?
Your Honor, it is, he's charged with carrying a concealed weapon by a convicted felon in another state,
Oh,
driving without a valid driver's license, and resisting an officer without violence.
okay.
The offer is for adjudication of guilt, 1 year probation, 50 hours community service, and forfeit the weapon.
1 year probation, forfeit the weapon,
50 hours community service.
50 hours community service, adjudicate. You want to do that, Mr. Reed?
Your Honor, in talking to him, he does not. He does want to have a trial.
624, thank you.
So contact my office so we can go over your case.
What's your name?
Lisa Ripper. Here you go.
Who we got here?
Brandon Severns, Your Honor.
Brandon Severs, okay.
Yes, Your Honor. He's before the court on 24 CF 629. We're going to enter a not guilty plea at this time.
Okay.
Request trial by jury and ask for the 624 docket.
624, thank you, sir.
I'll be out to talk to you once I've got some more information, okay? Thank you,
What about Rogelio Rosquero?
Not guilty plea was entered.
Dylan Sherman.
Mr. Sherman is present and approaching, Your Honor.
Okay. 24 CF 725, Mr. Sherman charged with possession of more than 20 grams of marijuana, possession of narcotics equipment.
Your Honor, we're going to enter a not guilty plea, request trial by jury.
Offers withhold, 18 months probation, substance abuse evaluation and treatment, 24 hours community service work, and $615 in court cost.
Changing the 6-month driver's license suspension as well. Your Honor, we would like to continue it to talk further with the state.
Okay. We'll just have a seat. We'll bring you back in a minute. James Franklin Spera, 24 CF 561. He's charged with attempted first-degree murder and aggravated assault with a deadly weapon without intent to kill.
Your Honor, we're going to enter a not guilty plea, request trial by jury.
624, thank you.
Couldn't come back there because he was,
Michael David Strauss.
okay? But I'll be back out to visit you.
Charged with, Mr. Strauss, charged with felony battery. Mr.
Offers adjudication, 767 in court cost, 18 months of probation, substance abuse evaluation and treatment, no violent contact with the victim, and no weapons while on probation.
Your Honor, he is indicating that he would be interested in taking that offer.
Strauss, please raise your right hand and be sworn. You swear the testimony you give for this court's the truth, so help you God.
Yes, sir.
You want to enter a no contest plea to felony battery, is that correct? You understand the rights you're waiving by entering this plea? You understand the rights you're waiving? Has anyone forced you or threatened you to enter this plea? Anyone forced you or
No, sir.
are you under the influence of any medication or drugs that prevent you from knowing what you're doing here today? Are you happy with the work Ms. Rivers done for you on your case? Court finds the plea is freely and voluntarily entered. Court accepts it. Run that by me now. Adjudicated guilty and what?
Adjudicated guilty of felony battery. It's a F3L1. And the state has a score sheet for you, Your Honor.
Okay, what was this agreed sentence? 18 months community control or something like that?
Probation,
18 months probation.
substance abuse evaluation and treatment, no violent contact with the victim, and no weapons while on probation.
All right, courts judge you guilty, sentence you to 18 months probation, have a substance abuse evaluation, completed recommended treatment, you're to possess no weapons or firearms on probation, and was it no violent contact with victim?
Yes, Your Honor.
No violent contact with victim, standard court costs, and waive cost of supervision, and cost of prosecution, cost of defense, all that.
Approach, Your Honor.
Yeah. Push that button.
Hello, this is Chris Norman at Bulldog Bail Bonds. Our office is in Crestview, Florida, but we service 7 Northwest Florida counties. If you ever find yourself in a jam, please give us a call. We're here to help you out.
Next case is 24 CF 558, Abby Sunday.
Your Honor, there's just one issue that I needed to address with the, I believe I needed to address with the,
Charged
Your Honor,
with-
she had indicated she's on SSI, and part of the requirement is she work a full-time job. That would mean she would have to lose her SSI. So that was,
Not full-time, but being gainfully employed. No. State's
So,
position
mean-
is,
She's Social Security disability or something? Is that what that is?
yes, Your Honor.
And you're incapable of working? I mean, you gonna require that?
one second. So she is charged with burglary of an unoccupied conveyance. So if she can run to a car and run away from a car, like, I don't see the issue with working.
So that means.
Well, what I'm gonna do is, what about the SSI, or she either is on SSI or she works? How about that?
State's amenable to that.
All right. So we'll do that. You either be on Social Security or working, okay?
You wanted a copy. Print it out.
All right, Ms. Sunday, would you raise your right hand and be sworn? You swear the testimony you give for us court's true, so help you God? You gotta speak out loud.
Yes, sir.
You want to enter in 24 CF 558, burglary of an unoccupied conveyance, no contest plea, that's third-degree felony, and 24 CF 689, count 1, possession of a controlled substance, a third-degree felony, and 24 CF 689, count 2, possession of drug paraphernalia, misdemeanor, correct?
Yes, sir.
Is she going to lose her Social Security if she's adjudicated?
No, Your Honor.
Okay. You want to enter a no contest plea to those charges, correct?
Yes, sir.
Did you read and sign this plea and sentencing agreement form?
Yes, sir.
Are you aware of the rights you're waiving by entering this plea?
Yes, sir.
Anyone force you or threaten you to enter this plea?
No, sir.
Are you under the influence of any medication or drugs that prevent you from knowing what you're doing here today?
No, sir.
Are you happy with the work Ms. Rivers has done for you on your case?
Yes, sir.
Court finds the plea is freely and voluntarily entered. Court accepts it on count 1, 24 CF 558 and 24 CF 689. Since you 2 years concurrent drug offender probation, have a substance abuse evaluation, completing recommended counseling, maintain gainful employment, or submit 3 job applications per week, or you can be on your Social Security, either employed or on Social Security. Take the anti-theft class, reserved for 90 days on restitution to Kristen Miller, 415 court costs on 24 CF 558, 515 court costs on 24 CF 689, cost of prosecution, $100 on each case, $100 PD fee on each case, $50 app fee on 24 CF 558, on count 2, 24 CF 689, credit for time served, and that's it. Adjudicated on all counts. Thank you.
May I approach, Judge?
Yep.
One more thing, I know a little bit about her case. She's trying to help this lady watch after her father. And
Yeah.
we were riding with her. One of the conditions was substance abuse evaluation and treatment. Would ECLC suffice for that because she does live out in the Baker Holt area?
Yeah, that's fine. Okay.
Thank you.
Todd Taylor, 24 CF 576.
Your Honor, apparently the jail didn't bring him over. Yeah, so, Your Honor, we can go ahead and do arraignment without him if the court's so inclined.
Yeah, all right. Plead him not guilty, I guess.
That's correct, Your Honor. Not
Pretrial
guilty.
conference 624.
Thank you, Your Honor.
Next case, 24 CF 595, Ryan Thomas. All right, Mr. Thomas, you are charged with vehicle theft and resisting an officer without violence.
Your Honor, there's one thing I've got to indicate. Your Honor, we've reached an agreement in this matter, if I may approach.
All right. Mr. Thomas, would you please raise your right hand to be sworn? You swear the testimony you give for this court's the truth, so help you God?
Yes, sir.
Thank you. This is State of Florida versus Ryan Thomas, 24 CF 595. You want to enter a no contest plea to the charge of grand theft auto, third-degree felony, and resisting without violence, correct? And first-degree misdemeanor. Did you read and sign this plea and sentencing agreement form?
Yes, sir.
You understand the rights you're waiving by entering this plea?
Yes, sir.
Anyone force you or threaten you to enter this plea?
No, sir.
Are you under the influence of any medication or drugs that prevent you from knowing what you're doing here today?
Sir.
Are you happy with the work Ms. Rivers done for you on your case?
Yes, sir.
Court finds the plea is freely and voluntarily entered. Court accepts it. Judge you guilty both counts. 2 years community control on count 1 with 1 year concurrent community control on count 2. $415 court costs, $100 cost of prosecution, $150 PD fee, waive cost supervision, 50 hours community service, which I'll let you buy out if you want to. Maintain gainful employment or submit 3 applications per week. Make contact on the Talking Parents app, Addie Honley? Who is it?
Your Honor, the issue that we had reached had to do with the contact because the victim in the case is his children's mother.
What's her name?
agreement that we've come to is that he can have contact about the children on one of the talking apps, or she can request in writing to probation for contact.
That is the agreement.
And who is that now? The mother?
Yes, Your Honor, the mother of his children.
Okay. I'll just write mother of defendant's children. Okay. And adjudicated on both counts. Is there anything else we need to talk about? Okay.
Judge, no drugs or alcohol while on community control.
No drugs or alcohol while on community control. Okay? All right, thank you. Justin Williams. All right. Mr. Williams, you're charged with felony battery resisting an officer without violence, 24 CF 678.
Your Honor, that is Justin Williams, T-I-N, and he was in court this morning.
Oh, so
This is Judson, J-U-T-S-O-N, Williams.
All right.
He's the next one on the docket, 24 CF 650, aggravated battery with a deadly weapon and misdemeanor battery.
All right, you're J-U-T-S-O-N, Judson. Is that right?
Yes, sir.
And Your Honor, we're going to enter a not guilty plea and request trial by jury.
Okay.
And, Ms. Reyes, you're aware he has a probation offer?
Right.
Yes.
Right. You said 1129 plus the 2 years of probation. The original offer was 5 years of probation with Phoenix House.
No, I wouldn't do Phoenix House. I would ask for ECLC and drug offender probation so that, that would be my,
So no incarceration? up front?
no.
Okay, see,
I don't have, no incarceration.
do you? He said he would be interested in that.
Would y'all, was it just straight 2-year probation concurrent?
2 years of drug offender probation, Your Honor, concurrent, do the ECLC program, which is out in Baker, out in that area, and you would do that instead of the substance abuse evaluation and counseling?
Well, what's that? I've never.
Is that adjudicated guilty?
Yes, Your Honor. So it's,
Thank you.
yeah, and there'd be no contact with the victim, and no alcohol or drugs while on probation,
I have anger management.
and anger management.
Yes, that's fine.
767 in court costs.
Standard court costs?
Yes, Your Honor.
All right, Mr. Judson, J-U-T-S-O-N, Williams, 24 CF 650. Would you please raise your right hand to be sworn? You swear the testimony you give for this court's the truth, so help you God.
Yes, sir.
You want to enter a no contest plea to the charge of aggravated battery using a deadly weapon, is that a second degree felony?
Yes,
Is that
Your Honor.
correct? And and misdemeanor battery. So you want to enter a no contest plea to those 2 charges, correct?
Yes, sir.
You understand your rights you're waiving by entering the plea?
Yes, sir.
Has anyone forced you or threatened you to enter this plea?
No, sir.
Are you under the influence of any medication or drugs that prevent you from knowing what you're doing here today?
No, sir.
Are you happy with the work Ms. Rivers done for you on your case?
Very much, sir.
Court finds the plea is freely and voluntarily entered. Court accepts it. Judge you guilty on both counts. Sentence you to 2 years community control.
Oh,
No, Your Honor, it was 2 years of drug offender probation,
Oh, okay. 2 years of drug offender probation.
and then on count 2, it would have to be 1 year concurrent.
Yeah, and that's on count 1, and 1 year's, and count 2 is 1 year probation, concurrent drug offender probation. Do the ECLC, no contact with victim, have no drug or alcohol without a prescription, take anger management course, and standard court costs.
And Your Honor, from what
Yes,
I'm
sir.
being told, probation is requiring that we have to say that there would be ECLC instead of a substance abuse evaluation class.
ECLC instead of a substance abuse evaluation, waive cost of supervision.
Thank you.
And adjudicated guilty both counts. Montana Yaws.
Your Honor, we've reached an agreement in this matter, if I may approach.
Yes. This is 24 CF 706.
And Your Honor, he's going to be plead to 2 other cases as well.
And 23 CF 257, 23 CF 2574, 24 MM 29, and 24 CF 706, correct?
Yes, Your Honor.
All right. Mr. Yaws, would you please raise your right hand to be sworn? You swear the testimony you give for us, course of truth, so help you God?
Yes, sir.
All right, in 23 CF 2574, you want to enter a no contest plea to grand theft, correct?
Yes, sir.
In 24 CF 706, 1 count of fleeing and attempting to elude a third-degree felony. You want to enter a no contest plea to that charge?
Yes, sir.
In 24 CF 706, count 2, possession of a controlled substance, a third-degree felony, correct?
Yes, sir.
And then count 3 is possession of less than 20 grams of marijuana, a first-degree misdemeanor. You want to enter a no contest plea
Yes,
on
sir.
that? And in 706, count 4, possession of drug paraphernalia, first-degree misdemeanor. And count 5, resisting without violence, another first-degree misdemeanor. So you want to plead to those charges, correct?
Yes, sir.
And in 24 MM 29, 1 violation of probation, a first-degree misdemeanor, correct?
Yes, sir.
Did you read and sign this plea and sentencing agreement form?
Yes, sir.
Are you aware of the rights you're waiving by entering this plea?
Yes, sir.
Anyone force you or threaten you to enter this plea?
No, sir.
Are you under the influence of any medication or drugs that prevent you from knowing what you're doing here today?
No, sir.
Are you happy with the work Ms. Rivers done for you on your case?
Yes, sir.
Court finds the plea is freely and voluntarily entered. Court accepts it, adjudicate guilty on all cases, all counts, and 23 CF 2574 and 24 CF 706. You're sentenced to 1 year community control, waive cost supervision, have a substance abuse evaluation within 30 days of completing recommended counseling. Must begin counseling within 60 days, random UAs, maintain gainful employment, or submit 3 job applications per week. In 23 CF 2574, you're sentenced to court costs of $415 plus $100 cost of prosecution and $150 PD fee. On 24 CF 706, court costs are $515, $100 cost of prosecution, $100 PD fee. And in the misdemeanor case, the court's going to revoke and terminate probation. And let's see, those, all that community control is concurrent with each other, correct?
Yes, Your Honor.
Okay. So get that done and don't break the law,
All right, yes, sir.
okay? Thank you.
Cost of supervision waived, Your Honor.
Yes. Is that it for arraignments?
One other case you had asked me to,
Oh,
so we're going to see if we can.
And there was another case that I had passed from this morning, Judge.
okay.
We have one guy that you called earlier, Donnie Ray Adams. He's here now.
Donald Ray Adams, come on up. Did I use your capious for him?
You did. We'd ask to recall that, Your Honor.
All right, I'll recall it. This is 24 CF 636. Mr. Adams, you're charged with possession of controlled substance without prescription and possession of narcotics equipment.
Your Honor, Tim Gibbs on behalf of Mr. Adams will enter a not guilty plea, request 15 days for any pre-arraignment motions, request trial by jury, and leave this set for pretrial June 24th.
June 24th. Thank you. Get with your attorney, okay?
Thank you, Judge.
Thank you.
Sorry I was late.
It's all right.
Yeah.
Well, it's not all right. Just don't do that again.
Yes, sir.
Give me a call. Set up an appointment.
You want to go to our 2 o'clock docket?
We can, Your Honor. I think Mr. Flowers has a
All right,
case.
23 CF 394, State versus Seth Chansey.
Judge, the only thing I'm concerned about is please instruct them not to send Mr. Kemp back to the jail. He still hadn't entered his plea yet. I'm not trying to step on Mr. Flowers.
I didn't take it that way.
Okay. Let me get your signature there, Mr. Kemp.
What is this?
Yeah, this is the 100 Days County Jail with credit for time served. They've agreed to that, okay?
Okay, we couldn't take care of the misdemeanor with it?
No, sir, we can't take care of a misdemeanor in front of a county court judge with this case. No, up here, sir. Here, this will make it, yes, sir, 120 days with credit for the time you have served. You mind if I go ahead and date this for you?
Oh, go ahead.
Okay.
You good? To sign this?
So that,
No, it's okay. Don't worry about it.
Yeah.
Basically, Judge, it's going to be an admission on the BOP for on sentence of adjudication of guilt, 120 days county jail. His underlying charges, the charge they pled to, were a lesser included misdemeanor offense. Misdemeanor offense, so there's no score sheet.
All right, this is 23 CF 2674, State versus Charles Kemp. Mr. Kemp, you want to admit that you violated probation?
yeah.
Did I swear him in? Would you raise your right hand to be sworn? You swear the testimony you give for this court is true, so help you God. Mr. Kemp, you want to admit that you violated probation?
Yes, sir.
Did you read and sign this plea and sentencing agreement form?
Yes, sir.
Are you aware of the rights you're waiving by entering this plea?
I think so. Yes, sir.
Your rights are contained in this plea, like your right to a jury trial, right to remain silent, right to
Oh, yeah, I read that.
Well, there's not a jury trial because.
excuse me, right to a trial before me. You read the rights in this agreement.
That's
You
the stuff I went over with you last night, or was it 2-3 days ago?
It was last night.
It was last night, okay.
All right, you
Oh, it was
understand,
2 days ago.
y'all understand the rights you're waiving, Mr. Kemp?
Yes, sir.
Has anyone forced you or threatened you to enter this plea, this admission?
This gets me on probation.
Has anyone forced you or threatened you?
Okay, yeah, no, sir.
Are you under the influence of any medication or drugs that prevent you from knowing what you're doing here today?
I know what I'm doing.
Are
Yes,
you
sir.
happy with the work Mr. Williams done for you on your case?
Yes, sir.
Court finds the plea, the admission freely and voluntarily entered. Court accepts it, judge you guilty, sentence you to, is it
It's 120 days.
120 days county jail with credit for time served, standard misdemeanor fees.
Yes, sir, there's no additional cost because it's a BOP.
And adjudicated guilty?
Misdemeanor level fee.
Adjudicated guilty?
Yes, sir. I
All
think he
right.
was originally, in fact.
Okay,
Judge.
thank you.
He was. All right, sir.
Yes, sir.
Right. Seth Michael Chansey? Is that right?
Yes, sir. And Judge, before we start, Ms. Young pointed out something to me because she's a professional and that's how she conducts business, and that is this. In the motion that we filed to reinstate the bond that the court had revoked, I pointed out the fact that he has been arrested subsequent to the case that he's on now, and he did take for driving. It was a .06, it was actually a .062 and .064 blood alcohol level, and that he was arrested for that. The state, when they got word of his arrest, moved the court to revoke the bond in the underlying case that this court is very familiar with. What I didn't point out is something that is located in the arrest report, and that is about 4 lines down in the arrest report. Mr. Chancey points out that he did take his prescription Ambien, and he did. In my motion, I failed to point that out, and the state's right. Now, in their motion, I might add, they forgot to point out that this case is the underlying case has already been tried, and a court already found that he didn't do anything wrong, and yet he's still facing criminal charges. The state, in their motion to revoke bond, failed to point that out, but I'm not bringing that up as it being a faulty motion. They just didn't say it.
Is this a dependency case?
The dependency case was tried, 5-day trial in front of Judge Oberleitz, and he found there wasn't sufficient evidence. We came before this court to ask that the child be reunified, and the child has been reunified over the state's objection and is thriving. Having said that, Mr. Chancey was in fact arrested for a DUI, .06 and .06. I pointed that out and was merely asking the court to reconsider that. But Ms. Leon accurately pointed out that in my motion, I didn't put some of the language in the arrest report that he had taken an Ambien that night, which he had. And so from the state's perspective, I think that, and she pointed out that I could cure my motion by adding the language that he took an Ambien. And so that's where we are procedurally, Judge. And I'm not alleging that she did anything in bad faith. She just pointed out that it should be complete. Theirs wasn't. They forgot to point out to the court that the case has already been tried and he's already been found not to have done anything wrong. That's where we are, Judge. And it's not her case. It's other attorneys she's filling in today. But they know that. The last time I was here, I accurately pointed out that everybody in the room knows that he hasn't broken the law.
So what are you asking for?
I'm asking to be reinstated on his bond.
What does the state say?
The state is objecting, Your Honor. This court has already correctly revoked the bond of this defendant because he represents a danger to the community. He blew .06 and he had mixed that with Ambien. This court knows very well what Ambien is. It's an hypnotic medication and it has effects that cause imbalance and forgetfulness, slowing reaction, and Ambien may impair thinking and reactions. Additionally, the report written by the law enforcement at the time of the arrest stated that there was a strong odor of alcohol. The defendant admitted of having drank alcohol along with the Ambien, which is not supposed to do, even if he's prescribed that. If he's prescribed that medication, I'm sure the doctor has advised him that he shouldn't be taking it with other substances, and moreover, is not allowed to drive machinery and drive automobiles. Also, the arrest report shows, and it's part of the court file, that he almost had a head-on collision with Sergeant Krause of Crestview Police Department. Additionally, he endangered the public by swerving and sharply making turns. When he was finally stopped, he admitted that he had drank vodka seltzer, and he also was found to have, on the driver's side, 6 packs of beer. The state believes that the court rightfully revoked the bond, and I think that it should stay in this way because of the danger to the community.
Judge, can I respond? Everything she just outlined is exactly what the first appearance judge heard on the DUI case, and he set a bond. This argument has nothing to do with the revocation in this case. They're seeking to revoke the bond in this case on a matter that a court has already found they don't have sufficient evidence even to meet preponderance of the evidence standard. Now, everybody in this room knows that.
What bond was set at first appearance?
I think it was $1,000 cash professional, no alcohol, if I'm not mistaken. And counsel that has that case is present, maybe Ms. Turner knows that answer, but a bond was set.
DUI?
Because I was there at first appearance.
That is still pending?
It is, Your Honor.
It's a recent arrest, Judge. and it is pending. We're asking as follows. Reinstate the bond in this case that the court's already ruled, there's not enough evidence to get past the JOA anyway. He's out on a bond on the DUI right now. He's working on the base. His child has been returned and is flourishing after the state took the child away from him. Not the state attorney's office, DCF. They, of course, lost that case.
Military?
I'm sorry, he is. He's in the Air Force, stationed at Eglin.
Yes.
Your Honor, I think we're mixing up proceedings here. First of all.
I agree.
First of all, the case was dismissed, the dependency case was dismissed because Judge Oberlisen didn't have the full report of the doctor. The report of the doctor was provided to Mr. Flowers after the case got dismissed.
Judge, it's
The
totally
report-
inaccurate information, cannot be more incorrect. That's not true.
Hang on 1 second.
But Judge, if we're going to start lying about things,
Well, I'll let you
No,
respond.
no, Judge,
it's not true.
the state provided the blood testing done by Dr. Sidonio, it's a pediatric hematologist and professor. That report showed no evidence that the child had hemophilia like the court with Judge Oberlisen was believed.
Well, hang on 1 second. I mean,
But that's
I want
It's
to,
also not
we're not trying that case.
Yeah, they've already
We're
lost
trying
that
to-
Yes, Your Honor, and my point is that the court has already ruled to revoke the bond. The state filed a motion, the court revoked the bond, and now he's asking for a rehearing
I
on
asked for a
that.
hearing the same day they filed their motion. The judge.
And this wouldn't be afforded to other
I filed a motion
defendants.
that very day for a hearing, that very day, and it was revoked without a hearing.
Because the court may, in its discretion, revoke a bond sua sponte when there is probable cause to believe that the defendant, out on pretrial release, committed another offense. So that offense that he committed about a month ago is still pending. It's not being resolved.
Yeah, and the case for which he's on bond, in this case, the state's already lost. The preponderance of the evidence was not met. They're prosecuting him right now for a case they cannot win, and they know it.
All right, what was his first bond that was revoked?
When was it revoked?
No, what was the bond?
$10,000. Cash or professional, it was posted, he's been living on the base and working. His child, over the state's objection, was returned to him correctly and is thriving. There's no reason whatever he shouldn't be at home raising his child right now. And quite frankly, this case being dismissed, but we're not here on that yet.
Well, Your Honor, there haven't been any depositions done in the case by the defense, so I don't know the,
Everyone's
Knowledge.
testified and they've already lost, all right? I don't need depositions, we've
The
already
issue on
won.
a bond is whether he's going to show up
Yeah.
or endanger the community.
He's never missed court, he doesn't miss work.
Sort of inclined to reinstate it with pretrial services supervision, no alcohol. While this case, all this is pending. And
Your Honor, I would ask for house arrest at the very least.
house arrest?
Yes.
She'd
pending
rather
the-
him not go to work, I guess.
No,
He can go to work when he's on house arrest.
I'm not going to do that. Just no alcohol. Reinstate the bond, but if you mess up, you're going to get no bond.
We'll send an order, Your Honor.
Okay.
Thank you.
Braven Gamble,
We already continued him to maintenance, Judge.
John Myers,
That's Mr. Williams, I'll get him tomorrow.
attorney? No bond capias, I guess.
Judge, I'm ready to proceed. The witnesses in the case, these are two ladies that gave statements that were listed as.
This is John Myers,
That's correct, Judge.
24 CF 663.
That's correct, Judge. Judge, just to give you a little background, currently has a no bond. My guess is that that was set by the first appearance judge based on the pretrial detention. I'm not aware of whether or not an actual pretrial detention motion was filed. I did not personally attend the hearing. We rotate that duty, and so one of the other public defenders would have. But what he's charged with is a series of third-degree felonies and a couple of second-degree felonies. There's no life felony involved, where a no bond would be traditionally allowed if the evidence was great. I've got two of the witnesses and attached to the motion copies of handwritten statements that they provided to our office, in which basically they, the court can read them and hear from them today. I'll have them testify and judge for yourself whether or not continued pretrial detention is appropriate.
I have that he's got 7 counts. Is that right?
Yes, sir. He's got
4
5
aggravated assaults, firing a weapon into a building.
Yes, sir, and one of the witness statements explains that that was apparently some sort of a tool that made a loud noise, and I'll have her testify about that.
Well, what does the state say?
Judge,
What do you?
it's Myers.
Oh, my, yeah.
No, it's got a possession by a convicted felon. It's got 2 F2s.
Yes. Your Honor, the state's offer is 85 months DOC with a 3-year minimum mandatory because he had a weapon. There is evidence that they found a spent casing and a hole in the car consistent with being shot at. So also, at the time of the arrest, the 3 victims corroborated one another's statement. And I understand that now they might have changed their idea about it. However, the state is going to go forward on the case. It scores minimum of 80 months DOC, and as I said, the offer is for 85 months with 3-year minimum mandatory. He's a danger to the community, obviously, due to the charges and the fact that he's a convicted felon and he's still assaulting people and shooting at people with a gun.
Well, Judge, the witness is going to testify today that it was not a gun. That I don't,
Is that?
I'm not here to completely try the case, but she's here today and prepared to
Are the
testify.
victims here saying, the victim?
One of them identifies herself as a victim. I think the other one identifies herself, or alleged victim. Do you not have the statements attached to the motion, Judge? I've got the statements right here, and I can hand them to the court. They've previously been
You're telling me
provided to the
it's some
state.
you're telling me it's some kind of tool, Ms. Leone says a gun.
Yes, ma'am, or yes, sir, but the witness says that it was an air hammer and that it hit the car and pierced the hood, and so somebody had a PTSD fit, and because of the alcohol, which triggered my own issues, it'd make more sense, Judge, for me to just give you the statement. I'd prefer to call them to the stand, have them sworn, and that way whoever needs to ask them questions can do so.
These are the victims? Alleged
Judge, this
victims?
is Aaron Matthews and Amanda Merritt. The,
Are they victims of fleeing, attempting to elude a law enforcement officer?
no, Judge, Amanda Merritt is listed as the victim in the aggravated assault with a firearm in count 2. Aaron Matthews is listed as the alleged victim in the aggravated assault with a firearm under count 1.
Who's the victim in the possession of a weapon by a convicted felon?
It says GLA, which I gather is one of the kids.
There is no victim, Judge. It's a possession.
Yeah, on the possession, that's a victimless offense, Judge.
Does the state have any witnesses that you want me to hear?
No, Judge, this is not set for a,
It's not set for a bond hearing?
for a pre-trial detention. No, I'm relying on the arrest report that is part of the court's file. And also,
What kind of bond are you looking for?
Judge, I believe I stated in my motion, he was requesting for $100 cash or professional.
$100? No,
He has limited resources
not
available.
with
to him.
80-something months.
if the court is inclined to give a bond, I would ask for $10,000 on the second-degree felonies and $5,000 cash or professional on the third-degree felonies.
Judge, he's not sure he can make a total $10,000 bond. He's not sure he can come
He's
up with
looking at
1,000.
80 months in prison.
I understand that, Judge. And I understand the state attorney's a one-man grand jury, and they can charge anything that they can swear that they've heard testimony to, okay? But we've got the witnesses here who are saying that it didn't go that way.
Well, the thing is, this is whether he's going to show up or not. He may be not guilty.
And that's,
From what you're telling me, he could very well be not guilty, and maybe the state will dismiss charges, and then everything will be a lot better. But right now, they're apparently not going to, and I'm not going to let possession of a weapon by a convicted felon off on a $100 bond or something like that. I mean, that's,
yes, sir.
and all these aggravated assaults. So I'll go with the 10,000 on the aggravated assaults each and 5,000 on the others each. I mean, that's better than no bond, and and maybe if it's like you say, it can be worked out. We were setting for 624, and maybe
Yes, sir.
maybe y'all can work out something that'd be a lot better. You can get probation or something, or if it's an accident or a tool or whatever the situation is. But we're not trying the case right now, so I'm giving you the chance of giving you a bond, but I'm not going to give him a RORs, which you're asking for when he's looking at possibly 80 months in prison.
Yes, sir. Judge, you said 10K on the aggravated assaults, and I did not catch the figure on the
5
others.
on the others.
5,000?
Yeah, on each, and 10 on each of the others.
All right, Judge.
Yeah, set them for 624, maybe y'all can get it worked out.
Yes, sir.
Get your witnesses to the state, and maybe the state will drop these charges. We won't be looking at those kind of charges.
We arraigned him.
That kind of time.
Yes, sir. Well, I've provided in reciprocal their statements some time ago, Judge.
Well,
But
the
we
state
arraigned
doesn't
him
want,
earlier
if it
today.
looks like, some kind of construction tool or something like that, then they'll let it go. But, until I hear all that or a jury hears that, I mean, I don't know. I can't just let him out ROR on those kind of charges. I mean,
Yes, sir. And-
it's not him, it's everybody, But if it works out, you know how I sentence. I'm happy to let people out on probation or dismiss charges. That makes me happier than I hate sending somebody to prison. But I'm not going to do an ROR kind of bond on all those charges, until it gets worked out with you and the state or a jury decides. And that's way too much time for me to take a chance in that kind of case. Those kind of charges just let him out on some kind of ROR bond. I mean,
Yes, sir.
it's too much potential time, but I hope it's like you say, and it can work out to something a lot less.
Yes, sir. Y'all, I don't know that she's going to have time to today, but if she does have and she wants to talk with you guys, can you stick around? Okay. All right, Judge, thank you very much.
All
That's
right.
all the cases that I have.
Do we have another person that wanted to enter a plea or something?
Your Honor, we have Dylan Sherman.
Dylan Sherman.
4 CF 725, page 9. Your Honor, the state is going to offer a pretrial diversion enter a plea, but we don't have the paperwork yet, so if he could have him back on the 9th.
Okay, May 9th, and if you enter this program and just complete it, they'll drop the charges, okay? But you got to come back May 9th and put it on the record. Okay, thank you.
Thank you.
What else we got?
We got 2 score sheets.
Okay.
from some pleas.
Long? Not mine.
Oh, it's yours.
Yeah, Shane Long.
Yeah, sorry, Lisa.
Oh, yeah.
I actually asked her. So what's the, you had,
20 months DOC was, or 5 years, and instead of Keaton, I said ECLC, and drug
Okay.
offender probation. I can write if you got the thing.
yeah,
You know,
I
I'm-
can give
I'm-
you one. Your handwriting's a lot better than mine.
I have the form you gave me earlier.
You do? All right.
Yeah.
Mr. Sprouse, there are several blank pages. I don't know if something was misprinted or something or
I
not.
looked at that score. That's how stack populated. Are you talking about y'all's?
Yes,
Y'all's, that's how it was populated.
okay.
I have this lady set on here to pay that rest.
There's just, it looked like something didn't print to me.
Yeah, she hasn't paid it yet.
When I was going over, it looked like there was
Who was it? It was
duplicates.
Jay Williams, right?
Yeah.
Yeah.
I can try to print it and see what happens,
23
Judge.
CF, 2880.
It seems like some, part of it's missing to me. See, because, see how some of these have got partial printing on them?
Yes, sir.